Good afternoon once again. I would like to request Liz and David to come back on. Um, First, I would like to thank our presenters, Liz Lenjo and David Kate, for making time to be with us today. I would like to thank our participants. We are now clogging about 35 for sparing time to join us, and I hope this session will be of value to you, also value to us. First, I'll just run through how we are going to manage this topic. This topic is both. It looks simple, but it's quite complicated in the way it's managed. First of all, I'll let my colleagues introduce themselves. Then we'll deal with the issue of authorship and ownership, because intellectual property is about entitlement, who owns what, and therefore what follows from that ownership or authorship. The rights in this, what can be traded, monetized, licensing of photographic works. Then we look at fair dealing. This is a public rights, part of intellectual property that people sometimes overlook. How can you use some of this for free? Privacy and image rights, where do they meet and where do they separate and divert? And then finally, we conclude with some final thoughts, some do's and don'ts that we would like you to take home. So first of all, I would like to welcome Liz to introduce herself. Karibu, Liz.
Asante sana. Thank you for the invitation. I'm happy to be here. Good afternoon, everyone. So my name is Liz Lendro. I'm an advocate of the High Court of Kenya, and I practice under the name and style of My IP Legal Studio, which is a boutique legal services firm specializing in intellectual property, entertainment, media, and fashion law. I'm also an adjunct lecturer at the Strathmore Law School, where I teach media and entertainment law and sports law. And I'm also the chapter lead of Creative Commons Kenya, as well as the lead for the creative or entertainment and culture lead. So I'll also touch about that as we talk about more on copyright and photography. So that's me in a nutshell, and I'm also a blogger. Thank you.
Asante, Liz, and you have so many hats. It's a wonder you are not wearing one today. Anyway, David, karibu sana.
Asante sana. So my name is David Kate. I'm an advocate of the High Court. I practice under the firm of James T. McCoy Advocates, and I specialize in intellectual property, entertainment, and I'm also a mediator. I'm also a patent agent. That's me. Yes. Yeah, I'm a pure practitioner. I don't teach anywhere like Liz.
Of course, it's good to specialize. Of course,
Yes.
my name is Edward Sige. I'm the executive director of the Kenya Copyright Board, probably in the style of that you guys have started with. I practice under the name of Kekobo. So it's my pleasure to host this session. And I think we'll start right off with I'll make a few comments now that a few years ago, several years ago now, over 10 years ago, Kekobo and WIPO undertook a study on the contribution of the copyright sector to the economy of Kenya. And we found that a category called photographic studios and commercial photography sector under the core copyright constituted 2% of the core copyright industry and 0.00305 of the national GDP. At that year, it contributed a gross output of about 670 million. I guess that globally, this contribution is likely to mirror the Kenyan position. So in short, what I'm trying to say is that photography has value in terms of the contribution into the core copyright sector. And therefore, we've taken this initiative of having this session for a number of reasons. The first reason is that every time I go into social media, I find people posting photos, and many of them do not acknowledge the ownership. Sometimes they even go as far as just saying courtesy. Secondly, I've seen a number of people who've taken photos of families, and they've used it in their trade, and therefore attracting liability in terms of privacy and image rights, which is also subject that is very closely related to photography as a copyright work. Therefore, I want my colleagues just to give their initial comments, and then we can discuss now the question of authorship and ownership in a copyright work. What are just your observations with regard to the matter of photography? What are the things that concern you as a practitioner in this area? I'll start with you, David.
Basically, for me, I think IP has not yet penetrated the market as much as it's supposed to be. And I think what we've been doing mostly in practice right now is trying to sensitize people so they get to be aware of what falls under the purview of intellectual property. When I was discussing with people and telling them about the webinar today, and people didn't understand even the difference between image rights and the issue we're discussing today about photographs, the issue of music and the rights involved, the overlapping doctrines of all these players in the industry. And I think basically we have a lot of work to do in terms of civil education. We need to educate people first about what is IP, because as far as we're concerned, I think in the economy right now, what we are left with, because our government is not doing much in employment, is now we'll have to go back to now being innovative, being creative, and generate money for the youth using this area of law. That's my few points on it.
All right, Liz.
For me, I think my greatest concerns are that most creatives are still stuck in the zone of, hobbyism when it comes to their craft. So they don't take it so seriously. They don't take it as a business. Yet when they lose out, when something happens, when an infringement happens, they're the first to call out these people and make noise on social media. Yet they did not sit down to think about what does the law say for their work, or rather provide for them. What does it state? How can they protect themselves and whatnot? As well as also having, just prudent business practices around their craft. Having a team and not trying to be everything in your business. I like to call that Pekiako Productions. You think you can do everything. You can be your lawyer. You can take your pictures. You can, all these things, negotiate licenses. It's crazy. So I think teamwork is something that is also important that they need to also realize, and also open their minds to the different business models that are ever changing and always being introduced in the market based on, digital products and inventions around the digital space. So I think my comment would be that we need to stop being fearful and being casual, and we need to take this more seriously, because even just from the statistics that Mr. Sigei has shared, we can see that there is value. And we hope that this conversation today will sort of just open the eyes of the various people present to show them the value of this industry, and specifically photography. Thank you.
Thank you very much for your comment. Now, for many of you who have joined this webinar, probably some of you are asking what really a photograph or a photographic work is. And maybe if you, from some of the definitions, including in the law, what we understand as photograph is really a still image or a picture. And that means anything that moves is no longer considered a photo or a photographic work for this purpose. And it is it comes about from the action that the person considered the author does with regard to the camera. In that case, I would like you to start from the definition, and then you could move then to who is the author and then who is the owner. so that we dispatch with the issue. Yeah, I'll let you please start on this topic.
All right, thank you for that. So I think when we're talking about photography, as we've highlighted, we have the author and we have an owner. And sometimes they can be one and the same person. So when we're talking about an author or authorship, we're talking about the creator or the originator of this picture that has been made. We're talking about the person who was in charge of constituting that photograph. They were in charge of the angles, the lighting, like they were very purposeful, basically. If it wasn't for their input, then none of the work would not have existed to begin with. So the author is the creator and the originator. And then there are instances now where the ownership may change, because ownership simply means who owns the commercial rights, who gets to make money from this work. And ownership may change from the author to a third party when there is now a contract, where it could be a contract by work for hire, where I, Liz, call you up and I say, hi, David, I would like you to take pictures of my people in the farm. We are doing a website. I'm having an event and I need some pictures to show my sponsors and people what my brand and my business does and things like that. This is a work for hire. So in this instance, an agreement needs to come in place where now I officially and in writing ask you to, or rather present to you that this is a work for hire and that ownership shall pass to me. This is one of those steps that I think photographers take for granted. So they always have this assumption, especially when we're talking about the doctrine of work for hire, that once they have, as long as they have been paid, they still own the photographs. That changes. And it's always important that an agreement is put in place. And especially now for the user or the person contracting the photographer, this contract becomes very important for you, because our act is very clear that copyright transmission must happen in writing. So that basically means for you that if you didn't have this contract, then the ownership still will vest in the author. So you want to be careful and protect yourself about that. So again, now you can see now in this instance, commercial rights now transfer. And when that happens, it means now the owner gets to commercialize. He or she decides how to make it available. We talk about that sets of rights, and they basically now take charge. And in turn, the author now retains their moral right, where now they are just they get to be attributed as the author or the creator of the works of the photograph, and that is a right that cannot be taken away, not by contract, not by anything. It's very express in law. I think I would say that in a nutshell. You're mute, Wanasige.
Yeah, I was coughing offline. David, do you have something to add?
Yeah, I'd like to add a few things. And I've gotten a request here from my village photographer, the one who usually comes with a bicycle every Sunday in the afternoon, that if we can balance the language and to involve kidogo na Kiswahili hapo, tafurahia sana kwa sababu hata ameenda kuomba mahali ya kutumia items. So ni vizuri akielewa.
Sawa.
Yeah, so if you can balance the two, and I think it will be good for them. So for me, I can say the author is the person who pushes the button in the camera. That is the author. When anafinya hiyo button alafu inalia, the that sound that the photo has been taken, is the author of the photo. And that I'm just putting it in plain simple terms, because we cannot always, even if you're told to take a photo in one room, we cannot not all take it from the same angle. Some of us are short, some of us are tall, some of us will embrace the lighting, some of us will just take without the lighting. And I can say the author is that person who pushes that, who pushes the shutter to create that click sound. Another thing I like to add is that when it comes to the owner, as my colleague Liz said, it's all about the work for hire contract. Hii nitajaribu kusema kwa Kiswahili so that mtu wangu understand. Ile picha ukipiga wewe ndio mwenye hiyo picha, you're the author of that photo. Lakini unaweza pata mahali mtu amekuita akakwambia ukuje kwa harusi yangu upige picha, alafu akupatie contract to sign, akwambie kutoka leo nikikulipa pesa fulani, hizi picha zitatransfer kutoka kwako na zikuwe zangu, kumaanisha huwezi enda kuzitumia mahali pengine bila ruhusa yangu. Na ama pia nikikupatia hizi pesa, hii picha inakuwa yangu peke yangu na nitaitumia mimi mwenyewe binafsi. So huyo ndio anakuwa the owner. So kuna hii tofauti ya hizi situations mbili ambayo kuna the author ambaye anaweza kuwa tu ni photographer ule wakuja kutembea, akona some rights in it. Then there's the owner who can pay to buy the rights from this person who took the photo. And that is all I'd like to add. Oh, one last thing. My colleague Liz had raised the issue about moral rights not being able to be passed on, which is very true. But when I was doing some research, I realized in Botswana and South Africa and the UK, they are coming now up with literature and arguments and cases in court whereby they are now starting to allow people to transfer their moral rights, which is not our practice right now. So that ukiona something different when you're reading about this, you'll see the different jurisdictions have different practices. Thank you.
Asante sana David. Nafikiri pengine kufafanua zaidi ni kwamba hakimiliki, wewe ni mwenye hakimiliki kutegemea kazi ambayo umefanya. Kazi ya kupiga picha, basi kama wewe ni mpiga picha, wewe ndio mwenye kazi. Isipokuwa wakati ambapo wewe umeandikwa kazi kama kwenye kampuni ama kwenye kandarasi. But there is something that probably people need to understand. You remember the monkey selfie case, US?
Yes.
Yeah. So kuna kesi ambayo ilifanyika Amerika, ambao nyani aliweza kupiga picha, na kuna kikundi ya kutetea haki za wanyama, PETA, ilipeleka kesi mahakamani ikidai kwamba yule mwenye kamera si mwenye hakimiliki kwa hiyo picha. Na pengine jambo lingine ni issue ya AI. Pengine hapo Kiswahili imefika kikomo. So there is another emerging issue about the future, the current role of artificial intelligence. Can artificial intelligence own copyright? Now, kama mko na Kiswahili ya kuita artificial intelligence, wewe ndio utazungumza kwanza. David, jaribu.
I think Liz is the teacher here.
Hiyo kesi ya nyani na hiyo kesi ya computer.
PETA.
Artificial intelligence ni kwamba hivi karibuni kutakuwa na machine ambazo zitaweza kuwa na uwezo wa kufikiria na kufanya mambo mengi ambayo wanadamu. So nafikiri I need your comments on the two issues. Kwamba we have an exception, animals cannot be owners, and we are now thinking, can machines now be the owners? Liz, kwanza, you have been at the coast, hebu tuonyeshe ile unajua.
Ile inaitwa ambush. Hapa kutakuwa na utohozi mwingi because most of the words don't have Kiswahili
translation.
Yeah, so utohozi utakuwa mwingi, but I think mwanzo it's to understand that tukiongea mambo ya hakimiliki na kumiliki in general ni haki ya mtu binafsi. It's not something that can be owned by a machine or a thing, right? Because when you understand the spirit of the law, kwa nini sheria zimewekwa zilivyo, ni kuhakikisha. Why do I have an echo?
Jirani amekuja, lakini endelea tu.
Oh. Yeah, so the spirit of the law is to just make sure that people of a state, their rights have been respected. So, but as time goes and things happen, especially when when we're talking about watu wa Ingereza, they have very interesting cases, and they're always trying to push the envelope when it comes to some of these arguments. So, like the monkey case, it took a number of
Baby, keep your eyes on me. Please mute. Sorry. Is it yours again, Liz?
No, it's not me. But just nikaanza kujishuku.
Our colleagues mute.
Yeah. Yeah. So as I was saying, when you look at the case about the monkey and the photograph, that case took a long time to be discussed in courts. And basically people were analyzing whether an animal can own copyright, and what does that mean? So what does that mean for our laws? What does it mean for animals if tutasema that wanyama wanaweza miliki properties, that they can own property, they can own IP. So I think for me, when I think about it, I think when it comes to the monkey case, I agreed with the opinion that the person who had been part of constituting, the environment, mazingara, kitambo picha ipigwe, that there was a purpose. By the time alika hiyo camera where aliweka, alikuwa na maono fulani, yeah. So just the monkey was just coincidental. The monkey came, and I was like, what does this button do? Beep, So anyway, can the monkey contract? Yeah, monkey haezi piga saisi kwa mkataba, haezi negotiate, hazungumzi. So things like that. And now when we talk about artificial intelligence, ambapo mashine inaweza kubuni, inaweza kuwasiliana na watu, inaweza kufanya all these interesting things, again pia machine inaweza contract. Can it get into an agreement with people and whatnot? So I think at the end of the day, it's about the person behind the machine, the one who is manipulating, because it is coming from someone's ideas and thoughts and that brain, that expression that they are managing to do it through this machine or through this gadget. So remember, again, copyright is about the expression of ideas, the protection of the expression of ideas. So I think for me, my thoughts would be, at the end of the day, when it comes to some of these things, I think there are sideshows. When it comes to ownership, authorship, I think it's pretty clear there. I don't think we're going to reinvent the wheel, in my view.
True. You would like to invent?
No, I wouldn't want to. But I saw an interesting argument when I was doing research on this. There's someone brought the issue of orphaned works. What if this monkey was in the forest? And clearly, if you go and claim right now and say that you want the author of this photo to be brought forward, you won't find him. So they were saying that this falls under orphaned works. And it was an interesting argument that I thought we'll discuss under RMIs when we get there.
I think our colleagues and those who've joined us are getting value with this discussion. So
yes,
the aspects and really is about capacity. So can an animal be able to click a shutter and take a photo? Yes. Can it manage property? Can it exercise the property rights? No. And similarly, I think we've had a lot of discussions. There are computer-generated works, and the person who makes the preparation for the work to be generated by a computer still remains the owner. And I think this is the argument. But there are, in our law now, we have not even considered that possibility of AI. But there was some, if you look at some comments after we passed the 2019 legislation, a number of people thought that we may be having a situation where a claim can be made under our legislation. But that is a discussion for the IP lawyers away from everyone else. But therefore, we have agreed that the authorship and ownership is we have established how it moves. But then, what are the rights that the owner of a copyright work holds? Of course, we had a mention already of the moral rights and the economic rights. Maybe David, you can go ahead and maybe share what do you think are the rights. The economic yes.
Yes, so the rights that lie in an economic, in a photographic work, the copyrights in photography, involve the right to reproduce the work. So when you take a photo, a very nice photo of the sandy beaches and the sundown, and you want to reproduce and sell because it is on demand, I think that falls under the purview of the author and copyright holder. That is the one of the rights that person holds, right to reproduce. The other one is the right to prepare derivative works. For example, you've seen there was an argument online about Ule Jamaa Kufinya, and from the photo, it was a still photo taken, I think, from a video, and there was a version that was later on brought that was a little bit animated and like a cartoon. So if that was a photo and the original photo was done through a camera and the photo was taken, and then the right to now come up with this derivative work, which is now more animated, is also the right of the owner, the author of the photograph. The other right is the right to distribute the copies. For example, we all have this photo of Jesus in our sitting rooms, in our shags. I'm sure Mr. Sigei, being a Catholic, you have that photo of Jesus, and I'm sure I'm sure if Jesus was here, he would be asking questions on how you managed to distribute all these photos without involving him. And whoever took that photo, even if it's Judas, we want to know where the distribution agreement came from. So the right also to distribute lies with the author of the photo, or the owner, if he's managed to buy and transfer the rights from the author. The other one is the right for public display. So that now we have this, I'm sure in all business premises we have the photos of the president. Now, if that was a private photo for somebody else, or somebody else took that photo in another different setting, that photo to display publicly for people to come and see and view and embrace its beauty, the angle, the details, is also another right that it comes with the copyright to the photography held by the owner stroke author, depending on the case.
It's, I think you've captured the major ones, but there's also the issue of the new rights making available. Liz, maybe you can mention them.
Okay, I think I'll just sort of just add on to what David has said. That now, apart from that, it's also just that right to make available, right to, that once you have taken this picture, it's your right to make it available to people, to the public, or whatever it may be. You can hide it under the chair or whatever you want, put it in a safe. And I think one of the things that is good about, like, for example, photography, is that for protection of photograph to happen in terms of copyright, it need not have been made publicly available. That is your discretion, as opposed to like what we see with like broadcast. A broadcast can only be protected once it has been made available to the public. And I think now for just to make things, to reiterate what David has said, your IP is your shamba, your copyright is your shamba, ni shamba lako. So wewe ndio una idhini, una hiyo control on how to sort of operate. Wewe ndio unaamua nani ataingia kwa shamba yako, nani atavuna, kama ni mahindi, nani atapalilia. That's basically the ethos around IP law, around copyright law. So it's basically about the right to control. You decide who to deal with, how to deal with your work, when to deal, and when you don't want to deal. Yeah, so it's simply about that. And then, of course, now I think one of the things when we are talking about these rights, that I think for us, Kenya, we are yet to really see issues around it, is now when there is a work for hire. When we're talking about moral right, about the right, aside from the moral right of attribution, where you are recognized as picture by Liz or drawing by so and so, created by, now there's the issues of the ability to refuse or object to distortion, mutilation, and whatnot. And I think in Kenya, we are yet to see a lot in regard to that. But like in the US, remember the sculpture of, I think that one was one of the interesting cases that we have seen, where this sculpture of a young lady in New York, and then someone put a bull next to it. And then the sculpture said that, the fact that they introduced the bull, there was some distortion of their artwork. So, we've seen those kind of cases in the US. Here, we are yet to see. It would be interesting to see how, a photographer can claim that once the commercial rights had transferred, how this picture was distorted. It would be interesting to see that. But I think at the end of the day, it's all about matters control, and you decide. And we shall see that shortly when we're talking about some of these contracts and how to, commercialize when it comes to photography.
Okay, thank you very much. Maybe in Swahili kwa ufupi, kuna aina mbili ya haki ama mtu anaweza kutumia. Ya kwanza ni ya kiuchumi, ya pili ni ya kibinafsi, ama ya kuangalia kwamba kazi yako inabaki vile uliweka mbeleni. So kuna haki ya kibiashara ama uchumi ambayo ni wewe unaweza kutengeneza zingine, unaweza kuuza hiyo kazi, unaweza kutengeneza aina nyingine ya kazi kutokana na kazi yako, na unaweza kuweka mahali ambapo watu wataipata. Na kwa upande ile ingine ya kibinafsi ama kwa haki moral rights ni kwamba kuna haki aina 2 ama 3. Ya kwanza ni kujulikana kwamba hiyo kazi ni yako, jina yako iambatanishwe na kazi yako. Ya pili ni kwamba kuna haki ya kukataa ile kutumika kwa kazi yako vibaya, ambayo ni shida kubwa kwa sasa with Photoshop. So uko na haki ya kukataa na kwenda mahakamani kuzuia mtu yote kuharibu picha yako bila idhini yako. Ya tatu ni kwamba unaweza uko na haki mbele ya kuitoa kazi yako, hiyo kazi ukatae kuitoa ije kwa umma. Yani unaweza kataa hiyo kazi baki kwako, usirelease ama publish. So hizo ni aina 2. So I think so for the purpose of right, there are many, and the person who controls is the person who is identified as the owner. Sometimes because the author may be different and the owner is different. So I hope there is no confusion in the terms that we have used. Now, kwa vile tumesema kwamba akimiliki ama umiliki wa picha ni mali ya yule ambayo alipiga picha ama yule ambaye alimwandika kazi. Kuna njia ipi ambayo inaweza kutumika kupata hela kwenye hii kazi ya upigaji picha? We have licensing, assignment. What other methods are available? And what are the key things really that an author and an owner take into account? We start with Liz again.
All right, so oops, I think I clicked a button, it's changed everything. So when we're talking about licensing, assignments and monetization, it's just basically how do you make money? Vipi utakavyo tengeneza hela na hizi hakimiliki with your photograph, how do you make money? So I think we start with the most easy form, which is the work for hire. I think when we are about intellectual property and copyright, we get stuck in the yangu, I must own, you know, and yet there will be opportunities where you will own it. There are opportunities you will be commissioned, ufanye kazi kwa niaba ya mtu na ulipwe. So that is what we call work for hire. So work for hire, I think, is one of the opportunities for making money, where you make your money, you're paid for this work, you take this picture, na unatembea na Yesu. You have made your money, you understand what it is that you have given up, your commercial rights. But we will always see, if it's your picture on a billboard, we will always see picture by David. And we are happy for you, and you made your money. So it's all about now negotiating. I think when it comes to contracts, the one thing that we don't understand is that contracting is about negotiating. It's about meeting of minds. Kwa hivyo mtu akikupatia mkataba and they are forcing you, they're telling you uko na 24 hours to sign, ama the deal is off the table, my friend, then you're better off without that deal. Yeah, because when that happens, it means that you're going to be given a very bad deal in that regard. And then now we have licensing. This is the opportunity or the ability for you now to have various parties use your work. So unawapatia license, leseni, ambapo wanatumia hiyo kazi yako for a period. So it depends with the people you're negotiating with. So utapata that one is on a case by case basis. If it's a big company, kuna vile utajitetea. It's about the use. How are they going to use your photograph? If they're going to use it on a billboard, if they're going to use it on print, like you have to understand all those things. Are they using it on digital? Maybe even understand what they're trying to push. If they're launching a new product, you've also understood maybe the kind of money this company makes, so that then also you negotiate a good license deal. So that's what about licensing. The good thing with licensing as well is that You can license for multiple regions, for different types of work as well, so that when you're negotiating a contract here, don't negotiate it in a way that umejifunga, you know. So for example, maybe I'm in photography, alafu there's an opportunity to collaborate. If I'm going to collaborate with, say, David, he's in the fashion business, kwa mfano, I'm very specific kwenye hiyo mkataba that I am giving him the right to use my pictures on t-shirts, on shoes, on trousers, on bags, period. Yeah. Asianze kusema oh ningetaka kutumia picha kwenye digital space sijui wapi, because that is nothing, he has nothing to do with that. So that means that sasa baadaye you can have another brand use maybe the same picture or another picture to market another product, or to use it, or to create something else that would be, you know, what we call derivative works. So at the end of the day, that is usually important to understand. So you have to understand the company that you're about to negotiate with, what are they trying to do, and then ensure that the contract is very specific. I think hapo ndio watu wanapotoka sana, because even us as lawyers, we are guilty of giving those broad clauses. We are reaching for heaven and earth and hell and you know. So you as the author or the owner, then ni muhimu sasa uelewe na uweze kunegotiate so that you have a good deal and you can sleep at night without nightmares. And then sometimes it might not be just about money, it's also about being known. It's about contributing to knowledge. So now in this instance, again, the Creative Commons license, I think tomorrow the CC in a circle online, yeah, that is the Creative Commons license. So the rationale behind Creative Commons is also to encourage creatives and authors and owners to, let me, for lack of a better term, to donate their work to knowledge as a public good. Because at the end of the day, ubunifu, we are when it comes to the art of inventing or innovation, or ubunifu, we are beneficiaries of knowledge, the public good that is knowledge. Kwa hivyo, knowledge is for everyone, right? So if we each contributed something small in terms of what we create to the body of knowledge, and we're able to say, chukua hii, you can share alike, you can use it to create something else, and whatnot, then it also helps. So the Creative Commons license is a very misunderstood license. When you go online, you will see that it usually has like drawings, and that's how it's sort of expressed. You'll see a man in a circle, you will see, which means that you have to attribute. If you pick this work online, then you have to attribute, you have to say the photograph is by so and so, any picture created by, and whatnot. Then derivative works, where it's an equals and around, it means that you can distribute, display, or perform copies of the work. So you'll find that all these signs, kuna share alike, the semicircle, then there's non-commercial, the $sign, alafu imekwa X, which means you cannot commercialize without the author. So basically with Creative Commons, it doesn't mean that you umepeana kazi yako, that someone else can make money without you. Yeah, unless now you express and deliberate with how you use the Creative Commons license. And you as a user as well, if you use photographs online, ni muhimu uelewe what, you know, what that CC covers, right? So that tomorrow, if it had said you cannot share alike, or it had said you cannot make money and you made money, you understand that you have done something illegal, you have, that is copyright infringement, na kesho utapatikana kotini, you will be slapped with a lawsuit and you will have to pay. Yeah, I think that's what I can say in terms of licensing opportunities and assignment. Again, we usually have, it's a semantic issue when you see the word license versus assignment. So sometimes you have to read the contract to contextualize, because in some instances, the word assignment can be used to say total transfer, which means umeuza kabisa, right? Especially now, like in work for hire agreement. And then you find some instances, the way the contract itaandikwa, it might mean it's a temporary assignment. So you always want to pay attention to how that contract has been drafted. Ndio uelewe kama hii ni a temporary assignment, which is because an assignment means a transfer of rights. So it can be temporary, it can be for good, it can be in perpetuity, depending on the circumstance and the fairness as well. Because we have seen also that contracts in perpetuity, which means forever and ever and ever we transfer some of these rights, it has to also make sense. It cannot be an unfair transfer. When it is, then of course the courts will find that it's not right, that itakuwa unenforceable na hiyo mkataba hata inaweza kuwa cancelled. I think something else to add is now just the issue of collaboration. When we're talking, once you understand the issue of assignment and license and whatnot, you're able to now collaborate or get into commercial engagements in various fields. I think for us, photography, we have really underutilized it. When you have talked about fashion, we don't see a lot of fashion collaborations with photographers. We don't see a lot of collaborations with video games and our photographers. That is an opportunity, that's a possibility, you know, contributing and collaborating with developers of virtual reality and augmented reality games. There's also possibility of photography to, you know, sort of come in play and be licensed in such instance. Of course, interior decor, David has talked about that picture of Jesus and many other. Remember that carpet of the dog smoking a cigarette? I just betrayed my age. I think most of us had that carpet in our homes, yeah. So we need to see more of that being done again, you know, interior decor, you know, issues of merchandising on a mug, notebooks. There's so many opportunities. It's just understanding whether it's your licensing or you're selling your IP, whether you're totally transferring your copyright, your commercial rights.
Yeah, Liz, you forgot to translate augmented reality, but I think consult your dictionary as David comes in. David, yeah, I think we are muted or something.
Yes, yeah, Liz has spoken intensively and extensively about the licensing and assignment. And I'll just like, so that I can be able to also relate with my people, I want to talk about how the issue of monetizing in simpler terms. There's something known as stock photography. This is where umekuwa ukipiga picha nyingi. For example, you love nature. You've been going around visiting national parks and other places. You can do stock photography and be able to upload these photographs, as many as you can, on some platforms online. Kuna moja inaitwa Shutterstock, kuna ingine inaitwa Dreamtime. You can upload there. Then you can decide on the type of license you want to issue on each of your portfolios, so that mtu akitaka kutumia photo from there, there's a way you can be able to monetize and have money sent to you as they get to use your photos. On the other, whatever, kuna farmers market ama flea market. These days naona pale K1 kama unatembea kule, unaona kuna kitu inaitwa flea market, wanauza nguo kidogo, mapicha nini. So unaweza tengeneza pia hizo picha kwa wingi, uweke kwa frame kadhaa, ukuje hapo set up, lakini obviously you will have to pay for the stand so that you can be able to set up there, so that the owners can get something from you being there and selling your stuff. You can also make a coffee table book. There's this book by Boniface Mwangi about the post-election. Alichukua collection zake za photos, akaziweka pamoja, bound and sold the book. You can do that. It doesn't have to be for violence. It can be for things you like. It can be for cars. It can be for people. It can be for models, as Liz said. And then you can do a coffee table book. These are things you can sell even to, like Java. They like having the same things on every Java because it's a franchise. You can do these books and distribute to all these places so that people can look at the good photos you've taken as they take their lunch or coffee. You can also do an ebook online, whereby you set up the ebook and you have your photos in the ebook. Also, there are channels to monetize through the ebook that is online. This is now for the digital photographers that we have. Then kuna kitu ilikuja mpya, sijui kama Sigeo utarelate, inaitwa OnlyFans. Kuna kitu mpya ilikuja inaitwa OnlyFans, where people take their own images and they post them there, and then for you to access them, you have to pay them. That's another way of monetizing, but I'm not advocating for it. I'm just saying there's another way of monetizing your images. Then you can also use social media, and you can also set up a blog, and you can find ways of monetizing. These are ways now I'm trying to give to the young people who are digitally aware, and for those who can do it in the analog way of doing the coffee table books and the farmers market and the flea markets.
Thank you very much, David. And maybe I can add something with regard to this. You know, to say that kazi ya hakimiliki ni iko mali na inategemea vile unaitumia, lakini inabidi uelewe haki gani uko nazo sehemu gani hizo haki zitaweza kutumika na mwingine, upige bei ambayo inafaa. Na wakati mwingine mawakili tumeitwa majina, lakini mara mingi ni vizuri uone wakili aangalie ile kandarasi ambayo unapewa, ama wakati unapiga negotiation, ama kama uko na, ndio baadaye usikuwe na shida ya kupelekwa mahakamani ama kulipishwa pesa nyingi ya damages. So ni vizuri watu watumie watu ambao wanaelewa kazi ambao wanafanya, na ni uhusiano inafaa kuandikwa. Maneno ya kukubaliana kwa mdomo kwenye bar ama kwa text ikubaliki kwenye sheria ya Kenya. So nafikiri nimeiweka wazi vile tunaweza kuangalia maneno ya upigaji picha na hakimiliki kwa jumla. Then nimeandika message kwa mkubwa wa KFCB juu ya kwamba David ameaccess OnlyFans. So nafikiri anashughulikiwa wakati
we shall hear from my lord.
Sasa, so jambo lingine kwa upande wa haki miliki ni kwamba kuna sheria ya haki miliki ni balance. Wanasema ni haki kwa mwenye kuwa na mali, na kuna haki za umma ambayo inaitwa public rights, fair dealing, fair use from other jurisdiction. Maybe I'll ask David to
I'm having a problem hearing you.
Yeah. Now, then I want you to just highlight some of the things that you think a photographer must understand on free use, the fair dealing.
Okay. 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 Sasa tumeongea kuhusu haki ya author, mpiga picha na mwenye picha. Lakini kuna kitu always kwa sheria tunasemanga there's always an exception to the rule. Tukisema kila mtu akona freedom of expression, bado sheria inakuja inasema kuna wakati ambayo tutakatazwa kujiexpress vile tunataka kwa sababu ya kitu fulani na fulani, maybe tukiincite watu wapigane ama kitu kama hiyo. So pia kwa copyrights photographs kuna a similar situation inaitwa fair use ama fair dealing depending on where you come from. Na hizi ni zile nyakati ambazo picha zako zinaweza tumika na ukose bila ruhusa yako, na ukose kulipwa kwa sababu ya hiyo utumizi. Na I'll try and outline a few of these instances. And one ni kama kwa news reporting. Saa zile mwanahabari anapeana news pale na ana update the public and address something of public interest. It is one of the situation whereby your work can be used, and that is fair use because it's for public interest. The other situation is for education purposes. For education purposes ni kama Liz akiwa pale kwa class Strathmore wakifunza wanafunzi wake, wa decide watatumia kitabu ambayo mimi nimeandika akiwafunza, wakifanya research watumie pia kitabu nimeandika. Hiyo ni fair use, lakini italingana, you have to qualify it, kwa sababu wewe sema unatumia certain passage kutoka kwa hiyo kitabu, then you end up using the whole book, and then and also the purpose of this shifts from now being educational, and maybe you decide now that since you've come up with something slightly different from what the author came up with, we will try and get money from it. So hapo kwa education kuna limits pia, na pia pale kwa news kuna limits pia, lakini kwa hii education ningetaka kufocus sana on the use. The more you use it, the more you use it, the more you will need to get a license from the author. But if you're just using it for educational purposes, a small excerpt of my works, then that is also allowed as fair use. Then kuna kitu kingine inaitwa criticism ama review. For example, tunataka discuss photography ya Boniface Mwangi na nilete hapa. So wanasema for that purpose ya criticism and review, the photograph has to be accompanied by the criticism or the review. Siwezi kuja tu niweke hapa na ni post na niende. It will change from that to public display, and maybe I'm charging people and nimeweka M-Pesa message hapo, wakikuja wakiona wananilipa. So if you're using it for news, you're using it for criticism, you're using it for education purposes, pia kuna limits as to how far you can go with it. So I'll let Liz also contribute before I also just highlight something else on satire and parody, because I know there's a thin line there that I'd like us to discuss.
Right,
Yes.
Liz.
Yeah, I think he's right about satire and parody and that thin line. But yeah, I was going to say that, just to add, apart from what he said, other uses ambazo where it's exception idhini ya mwenye picha si lazima is also mambo ya parody and satire. Hapa ni mapo where we are mocking, tunaiga some of these things. We are just making statements, but in a satirical manner, in a manner that inachekesha. So I don't know if I've seen photography as much in terms of parody, but I am sure there is in that regard. Or hata hiyo picha ikawa transformed into a derivative works, into a chore instead in this instance, alafu maybe aongeze cartoons or whatever it is, or they're making a statement and then it's satire or parody. That becomes a fair use, inakuwa mambo ya fair dealing or fair use. And then I think incidental use is something else that I think it's still we are yet to know how that looks like. I think I've interacted in cases where I was like, is it incidental use? Was it deliberate? Because incidental use is about it happened to, it was by chance, haikuwa planned. So kama kwa mfano your picture was say part of street art, or it was in an exhibition, alafu msanii alikuwa na record mziki, and then your picture was in the background, but for maybe 2 seconds, yeah. So that maybe would qualify as incidental use, because it just happened that alisimama hapo akipita, or someone was passing, or whatever the case may be. But then if it features again too much, again, when it comes to exceptions and limitations, it's about how much have you used the work, or how much have you displayed the work. Again, so hapo pia with incidental use becomes, there's also now a very thin line, so that then we do not abuse the rights of the author or the owner. It's basically, like it says, fair use, that you didn't haukukandamiza mwingine for your benefit. I think that's what I'll add. I'm very curious to hear your thoughts on satire and parody.
Right. In most cases, on this matter of fair dealing, we must admit that it's very, very, the options for the use of a picture, photo, or an image are limited. And as outlined by David. Second thing is that there are uses which are limited by volume or nature. That means if you are making money, or the image that you are claiming to be incidental in the news reporting or the video must not be the thing that only people notice in the use of your work. So everything is on a case by case. But let's hear David on the issue of satire and parody, because I'm not sure how that would come out, because we have, in that case, you're also looking at changes that have been made, probably without authority. Then it takes it out from the protected use into the use that is an infringement. Please go ahead, David.
Yeah,
disappearing.
Yes, I left this specifically out because there's a lot of literature, and depending on which angle you want to take it, people have different opinions out here. And first of all, I like to distinguish the two between parody and satire. Kuna watu wengi hapa wana watch XYZ. XYZ, unaona Tuoli pale ametengenezwa kidogo kama cartoon. Unaona Jeff Koinange pale ametengenezwa kama cartoon mwingine. Na wanatumia hiyo kunena kuhusu kile ambacho kinaendelea saizi katika nchi. Hiyo ni angle moja tunaweza sema satire. Then there's another angle ya parody. So for parody, I don't know how I can put it in Swahili. Liz, maybe you can assist. But parody is when you use the same creative work to criticize it. So basically, tuseme mtu amechora picha ya Yesu akiwa kwa msalaba. Okay, that would be blasphemous. Let me get another example. Maybe picha ya mtu akiwa pale Uhuru Park. Mtu akuje afanye some alterations kuonesha vile yule ambayo alikuwa anachukua hiyo picha angle ambayo angechukua ingetoa another meaning. There's a way you can take a photo, then the shadow brings out maybe, for example, a perverted aspect out of it. And somebody else comes with the same photo, having done it just to criticize this one. And that's the point. So what wanasema, if you see these two aspects of parody and satire, what wanasema, still you're generating a new idea that people did not see, either through the comic effect or through the criticism, and they are saying that this angle is also copyrightable. So other jurisdiction wanakubali satire, other jurisdiction wanakubali parody, other jurisdiction wanasema no, you have to come up with original works. So, and that is why I left it out for people to know, and maybe it's a good case study, and I think we can develop on it.
All right, thank you very much for your comments on this. We need now to move to an issue also where you find interference, privacy. Watu wengi wanafikiria kwamba wewe kama umepigwa picha wewe ndio mwenyewe. Tumesema kwamba ni mpiga picha ndiye anapiga. Now what happens with the mpigwa picha? Ya pili, image rights. Sasa kama mimi mtu wa Nyakaminja naweza kuclaim image rights. At least you go first. That's two issues.
All right. So I think when you're talking privacy and image rights, it's important in photography, especially when we're talking about subject photography. You're photographing people and people's spaces. Yeah. So ni muhimu that uwe mwanzo na idhini ya kupiga picha kwenye that space. Kama ni nyumba ya mtu lazima uwe na idhini. Kama ni picha yangu mimi unanipiga binafsi, tuafikiane why you're taking this picture. Sorry about that. Lazima tuafikiane why you're taking this picture na utaitumia vipi. Now when we're talking about as we said earlier, yule anayepiga picha ana yule ako in charge of maybe the setting, the investment and whatnot, ndio mwenye picha or mwenye kazi at the end of the day. Sorry, I lost my trail of thought. That phone call just confused me. Yeah, so as I was saying,
mpigwa picha na mpiga picha.
Oh yes. So yeah, so that consent is very important. Yeah. Already we know that the one who takes the picture is the author, right? Now if it's a work for hire, it is my picture. Mimi ambaye nimepigwa picha. We have seen cases where celebrities are being sued for using pictures because they didn't have that. They don't have that right, that copyright. We've seen, I think, Britney Spears. We've seen a few other celebrities being sued in that regard because it's about the ownership. Now, there's this related right now when we take people's pictures. Now we're talking about privacy versus image or personality rights. So first, let's distinguish the two. If I am a celebrity, I have what is called image rights or personality rights because my image and my likeness is distinct enough that when people see it, they're like, oh, it's Liz the lawyer, oh, it's David the lawyer, it's David the artist, or things like that, right? So I am able to earn. My image already has a value. I earn from it, right? So the minute you take my picture, it has to be very clear if you're going to use it, how you're going to use it. Without my consent, then now I may come after you under now that common law right where you have interfered with my personality rights, with my ability to earn from it. So for example, kama mpiga picha uchukue picha yangu alafu uweke kwenye mugs, kwenye handbags, fashion items or whatever it is, and you say, oh, I have a new fashion line or something, right? Then I'll come after you because I could have earned, right? I've been earning as a celebrity from the use of my image, and now you've taken this away from me, so I will come after you for that. So when it comes to, when you're photographing personalities, ni muhimu that you are very clear. By the time unaweka hii picha kwenye social media, pia mko na mkataba where you have agreed that I took your picture, but I have requested, we have agreed on portfolio rights where I can say I was once an official photographer of you, and you've given me the right to add this picture on my portfolio, right? So that then tomorrow I don't go after you. Again, Pia, you have to be very clear about that use. So if you go outside the use of the portfolio use, you're going to be in trouble under that common law right. Now, when it comes to privacy, this is about now a personal citizen. It's about Liz, who is not known, a private person. I was going to the M-Pesa shop to remove some money, then kaching, kapiga picture. Yeah. Why are you taking a picture of me? Do you have my permission? I'm doing my own things. Why? It's things I do in my ordinary course of day or life. Hauna sababu ya kuchukua. Even, when you're talking about news, as David said, they have to have that consent. So lazima kuwe na sababu, and you have to ask me, the permission to use my picture. Otherwise, now it would be an invasion of privacy. Even with celebrities, it doesn't mean that they don't have privacy, right? If you take a picture of, say, a celebrity living a bathroom or something, or outside their house in their pajamas, that is invasion of privacy, yeah? So privacy is about that, interference in someone's personal space. They are not in a public space. When you're in a public space, things will change. You'll be able to take that picture, but again, it will be about context. Will be a very big deal. How you're going to use the picture, how are you taking it, where were you taking it? If it's in a public space as well, it doesn't mean that public spaces hazina watu pia, like hazina wamiliki. In this context, we're talking about the county government, the county councils. They're the ones now you have to go and take a license before you go and take pictures up on Mamangina Street. Before you take a picture of Mount Kenya, you have to go to talk to Kenya Wildlife. You need all those permissions, because otherwise they will also come after you. So you always have to understand the context, the people you're using, why are you taking this picture, where are you going to put it, do you have their consent before you find yourself in trouble. And then David talked about even now these the Shutterstock, these images that we take. I hope we read those terms and conditions. So especially for the users, ambao wanapenda tu, I don't have money, nataka picha free, nataka weka kwa calendar, alafu ina sura ya David. Did you read the fine print? Because most of them, they have disclaimers, and they will say, we are not responsible for image rights. When you see that, my friend, move away from that picture, because you're going to be in trouble. Yeah. So when it comes to photographing people and people's premises and spaces, it is always important that you have cleared these rights, and you protect yourself with integrity. Ata when it comes to commissioned works, for example, say umekuwa commissioned na advertising agency na wewe ndio umeenda kupiga picha. You see, at the end of the day, your reputation as a photographer can be at stake if you didn't do the necessary work, because under agency law, utapelekwa kotini, na maybe pia mwenye ametumia hii picha atapelekwa kotini. So remember author and owner conversation. So in this instance, both of you mtapatikana kotini. But what happens to you after this kama mpiga picha? You might lose your credibility as a photographer, because unasema, sikujua sheria. We say ignorance of the law is not defense. You must know the law. Yeah. So which means that even in your business practices, lazima uzielewe na uzitumie, weke mikakati na miradi to ensure that unaheshimu sheria. I think I would say that in a nutshell.
Liza amesema kuna sura ya kawaida na sura ya kazi.
Yes,
so cheza na sura ya kazi ambaye celeb ama mtu ambaye kama sasa mwenye very soon ameanza kuwa kama image that you have to be more careful. Alafu kuna idhini ya kupiga picha kwa wakati ambao unafaa. Hiyo ni kitu kingine mtu anafaa kuwa nayo. David, pengine hapo.
Yeah, for me, I'd like to say that when we are talking about the privacy, I'd like to add on something. Now that our country doesn't have like solid legislation on whatever privacy, we depend basically on the constitution when it comes to these issues of infringement. I read about the ordinance, the bailiwick ordinance. There is a country known as the bailiwick of Guernsey. So the bailiwick of Guernsey is one of the English Channel Islands. And there are three of them. One is under the protectorate of Guernsey. So in the bailiwick of Guernsey, they actually set up legislation for this. And they have an ordinance that was passed in 2012. It's called the Bailiwick of Guernsey Ordinance 2012, which sets out who is a person. Actually, they term it as personage. What qualifies as a personage? Is it a person? Is it a body corporate? Joint people in a photograph or such like things? So I'm looking forward to a day where we'll have legislation, express legislation, not just depending on affiliate and accommodating statutes regarding the issue of privacy and image rights.
So I think I agree with you that we need that. Several years ago, when I was still young, I wrote an article, the photography, image rights, and privacy. That is the same conclusion that I reached. So it's something that those of us who are able to test our website should be able to get that article in one of our magazines. I think it's probably 2014, 15, or 16. So I think those are the pertinent issues. Maybe now, maybe before we go and take questions, I see time is really moving fast. Maybe what do you have some things you would say everybody who is in this business must do? Maybe very briefly, if you need to explain briefly as well. We start with Liz.
Okay. I think. Sorry for my.
Yeah, you are all right.
That's
your phone again. Yeah.
All right. Yeah. So when we talk about the do's and don'ts, my take home for users and creators of photography works would be: one, if it's not yours, seek permission. Kama si yako, pata idhini ya mwenyewe ili you can create something legitimate, something legal from it. Then secondly, I would say it's important to read terms and conditions, especially when we're talking about online news, because terms and conditions are also contracts, ni mikataba, and they are binding. So just because you clicked accept na ukusoma, the position of the law is that wewe ulisoma, ulielewa, so you're bound by those conditions and terms. So you'll be liable if you go against them. Usipoziheshimu, utajipata kotini. And then kama mpiga picha ama mpigwa picha, it's always important to be clear on the terms of engagement and clear terms of use. Let's not be ambiguous. Let's not try and catch all the sharks and the omena in one net. Let's be clear what we are trying to do. And then ni muhimu, you always have a contract when it comes to mambo ya copyright, transmission of copyright, lazima kuwe na mkataba, muafikiane na mpige sahihi, no gentleman agreement. Alafu kwa mfano, if it's a work for hire agreement, especially for photographers, this is something that we see you do a lot. You have what is called the right of lien. Una haki ya kukataa kupeana hii kazi until you have been paid your full amount of money. Yeah. So if you've not yet been paid, the work is still yours. Hata kama umesign contract, lazima contract iwe fulfilled. Yeah. So itakuwa fulfilled kama wewe ushalipwa. So you have to be very clever. Otherwise, if you do not exercise this right, because it's yours, you don't need a lawyer even to tell you. Hujalipwa, kazi bado ni yako until the full money. So you have the right to keep this work until you have been paid, and then now you transfer the work. So be careful about even over delivering. Umeenda unapeana all the raw files, and maybe you are just told, give me 5 pictures. Protect yourself, right? It's always important. I think that's what I would say in a nutshell. Thank you.
Yeah, David?
For me, I'll just go back to the basics for what they do. The watermark, ukitoa picha inakaa vizuri sana na unajua watu wataitaka, weka jina yako hapo katikati, watermark the photo, andika hapo katikati Liz Lenjo photography, so that if anyone wants this photo and they want to purchase it, lazima wakuje they negotiate with you you agree on a license or an assignment at a certain fee, then you can give them the one that does not have a watermark. And that is very important. Second thing, when you take a photo, it's good to also give a brief description of it. You can say mountain or savannah photography by Edward Sigay, taken on 2010, so that people will be able to know if somebody else uses it later on. Unaweza weka pale kwa bottom right corner ya that photo, so that people will know who took the photo and when it was taken. It is very important. You can be able to do that. Those are the only 2 points I wanted to add on Liz's submissions.
Now this is this being the shallow end, the pool. I have a lot, and I hope our listeners have taken note of what Liz and David have shared. But I would like to add a number of do's, actually 12 do's. The first one is, as been mentioned by David, it's about, for me, I'll propose that you find a way to insert a link to your work every time, by name or whichever way. That's what we call the rights management information. And where possible, if it's online, you need to find a way, even including a method where you can be reached. The second one is, if you have to find a way to control access and copy of your work using the technical protection measures that are provided for you as an author under the book. The third thing is that you have to be assertive every time your work is used without authority by writing demand letters, cease and desist, take down and claim payment without delay. Sorry, many of our artists take time and they lose the delivery. Sorry, so it's very important to be assertive. It's about asserting your right. The fourth one is beware of license assignment and other monetizing opportunities. Take them up as they come. The fifth one is that you have to be vigilant online for unauthorized use and mutilation of your work. So it's very key that you follow where your work is going. There are tools for that purpose. The sixth one is we've just discussed about privacy and image rights. Every photographer must be aware of privacy and image issues, and you have to respect those boundaries that are, and especially with children and celebrities. Number 7 is that if photography is you're a professional photographer, you have to learn to leverage on tools that are available, the opportunities that keep coming up in online environment. Number 8 is that you have to know the value of your work. You have to place a value. Every picture has a value. You have to know the value. It's very important also, number 9 is to create portfolios with dates, places for record. That's what David has also said. Every picture is a story. And a picture without a comment, a place, or a context has less value. It can easily be mutilated. Number 10 is that you register the intellectual property in your work and or brand. Many of the people who do photography business are also people who have brand names for their business. So it's very key to register the intellectual property, whether as a trademark or even as a copyright, and you have an opportunity to do that online in terms of copyright speak. Number 11 is just you have to keep an advocate with you all the time and consult with them on any matters that may arise in this business of yours. Number 12 is that the do is that you have to manage commissioned work in a contract to determine ownership and the scope of use. And also this may apply to employment. The default position in Kenya is that he who has employed you or has commissioned you is the owner. But you can also have a contract to the contrary. Having known that, then you can always negotiate for the contract to the contrary that you stay and keep your rights. The don'ts, in my view, they are much less than the do's, which is good, isn't it, David? So
Yes.
I think the don't is that do not ignore any unauthorized usage. As I said, it's just related to the question about nothing. If you don't assert, you always let somebody to come in, and they will always be asking you, I did that in 1990, and I did that in 2000, I did that, and you lose a claim. Do not delay decision making, and then do not ignore online opportunities. So those are some of the things that are just for the purpose of this session. But so it's very important that we understand the relationship between yourself and the person who gives you work, you and the person you are taking the picture of, what you are taking the picture. Know how to manage your resources. I do not know if I'm not seeing any, there's only one question, which I probably may have answered.
Wanasige, before you go to the question, on the issue of asserting the rights in photography, I wanted to add quite a few. And I'd like to insist on the photographers so, that anytime you see your photo posted by someone without your consent, if you're the author, it's very good to request for a photo credit immediately. You go and post there, this photo, I'm the one who took it, and I demand for photo credit, so that people will stop playing with your works. The other thing, you can also do a DMCA, Digital Millennium Copyright Act, whatever, takedown notice. That was usually available online, and you don't have to be within the jurisdiction of the United States for you to use it. You can also use a lawyer to do a cease and desist against anyone who infringes. You can also do a demand letter when it's escalated. You can also file a copyright infringement claim, but most of you now come and now value the cost of doing the case versus the works infringed upon. So basically, you have to value your work so that you get to know on if you're ready to go ahead with it. Lastly, you can do nothing, and you can do photography as your hobby. That is all I wanted to say.
Monasige, let me just add something small. Since he touched on that issue of digital, I think something else that's important is that we need to stop using social media as a court of law. It is just a court of public opinion. And what usually happens, that we have seen with some of our photographers and creatives in general, is that they destroy all that goodwill that could have been had, that could have been used to their advantage to settle a matter out of court. So the minute you decide to start abusing this person who has infringed on your copyright, you lose that goodwill and the work will even be harder. So even though you would have made good money, just know that if you retain the services of a lawyer, you will pay more money, because now we have taken over this headache to try and justify, I'm sorry to use this word, the nonsense that you have posted online and destroyed all the goodwill that we could have converted into shillings.
True, that's a very good point.
Yeah, it is very important. There's always, you have to have a strategy. And I think we have, I think, two questions on, I'm not sure if you're able to see the chat. I think one is from Kinyungu and the other one is from Grace Mohoro. The first one is that it was directed at you, David, and we are happy that it's directed at you. That when you say that using a photo for news qualifies under fair use or fair dealing, do you mean that media houses can escape paying the photographer for the use of their work?
Yes. Now, as I stated, the qualification for this has to be when reporting current news. See, or any other program that comes. You've seen, for example, Larry Madowo hosts news, and then he also does whatever the trend.
Yes.
So when you're updating the public, it's public interest. That is the only qualification you need. It's for informing the public of current affairs. When he does the trend and he brings the cut videos and other photos, that is not fair use. So you need to know the qualification is reporting of current affairs in public interest. That is the only qualification. But any feature in any other production is not.
All right. Liz, is there something you wish to add or sufficient?
I think also you determine that use by this media house. So if they decided to use billboards, they used a picture on a billboard. It was a commercial, like so maybe like the reels that they do to promote their stations, for example. That is not news. That is not fair use. So I think also that is always important to be aware of.
So any subsequent use not related to events where the picture was taken is not within that category. The second one is that Grace is saying most photographers are not familiar with the provisions of the Copyright Act in regards to the transfer of the IP. In that case, let me just see if I missed something. Yes, the work for hire, works for employment, they assume that the law is in their favor, which is not the case under the social circumstances. Have a contract to retain the contract. Is it? Yeah, so I think what Grace is saying is that many people do not understand, but I think we have ruled that default in Kenya is that I employ you to be a photographer. If you make photos, they belong to me as a standard procedure. Secondly, if you employ me to do on a contract basis to work for you to take photos under my direction, the law is in favor of the person who commissioned and employed you. But the law also say you can have an agreement that gives you the rights. So in that case, it's quite it's very clear. So and you can make your decision based on that knowledge. Then the other question is that image rights are under common law, and there is also privacy entrenched under the Constitution. I think we have dealt with it. Then the Jonathan says these magazines that use your photos and credit someone else. How do we go about? Liz, you can take this one.
So I'd say as a photographer, and I think even David just alluded to it earlier, he said that if this happens, you politely send an email or a message or a letter, just asserting your right that this was your photograph, and basically asking that in future they credit if they use your work. And you might even use that as an opportunity now to negotiate for work, because you can actually legitimately sue here because it is a breach of your moral rights. So the question is now, you as a photographer, you ask yourself, what is your plan? What is your goal as a photographer? Because you can turn, if you do this in a polite fashion, in an organized fashion, you can turn it into a business opportunity. If you use it in a cantankerous manner, it will become more of a liability and you'll have to go to court and whatnot. So at the end of the day, it's about that. You have to be tactful about it. And if you're afraid that you might be one of those cantankerous individuals, please get a lawyer. Then you can be rightfully assisted. Otherwise, the ship can sink very fast for you. But you have a right there. It's the how that you pursue it that's very important.
So unasema wakili ndio dawa ya katangara.
Otherwise account itakuwa minus even more.
Ricky's production says, I'm hoping this recording will be available. So it will be available. It's being recorded and it will be made available on our website. And I think you'll be also guided how to access it through our social media. Rogers Wambua said, what about photos taken in churches and posted on their social media platforms? Is the church exposed? David, you can try that.
I'll use the issue of when you that famous case, NWR versus Green Spot. The same thing as because church is also a business, and people make money out of church. So, for example, you go to Whiskey River or any other club out here, and then there's that photographer inside there. Then he takes a photo of you enjoying a beer, and then the next day you find yourself in a billboard promoting Tusker Keg, and you have no idea how it came about. The same way, the church is also a business, and it depends on the use now. If they use it now to advertise and their services, because obviously the impact of advertising is bringing more believers to come in and worship. That means more offering. That means more giving. That means more followers. So if they use it on the media, they use it in whichever other platform to try and attract more people, then you really need to do a letter, a demand letter through a lawyer to them, because you might have been visiting that church for the first time. Even a Muslim, you just came because my child was being dedicated or baptized, and now everyone knows you attend Sigei Pentecostal assemblies. So it's quite a serious situation. Yeah, and that is what I would like to say about it.
Yeah, of course, this doesn't apply to my ministry, but we had a question. I think it was it Patrick? Whoever it is, there's somebody who put up their hand. I cannot see it anymore.
Mugo K. Mugo K.
Mugo, please allow him. Martin.
Good afternoon, everyone.
Good afternoon.
I had some few contribution in relation to our topic today.
Okay.
And the first one is that in relation to whether artificial intelligence can own copyright, the Court of Appeal in the UK has ruled that only humans can be recognized as an inventor. In relation to, I also had a question. Could you kindly clarify the difference between image rights and photography, like how they work? How can one distinguish image rights and photography? Thank you.
All right, Mugo. Mugo, what we said is that there are people who make money from their images because they are well known. The sports people, the film people, the musicians, the celebrities, they usually sign contracts on the use of their image, and those images is their property. If you are not careful and you use their images, you may be in breach of their image rights, and they will sue you and they will get a lot of money. So in that case, you have to be careful. You can use the pictures of politicians and church people and public people like me, but you have to also be careful about privacy, that you don't take a photo when David is blacked out. You really have to be careful. Because now you are now infringing on his right to privacy.
Yes.
If he is dancing without a shirt, also you can post that one. In any case, you have to know what things, what boundaries you have to be careful about. Yes, so that you don't embarrass somebody. You can take an image and it's something that somebody will sue you for defamatory acts, breaching their right to privacy. You take a photo from the window. Of course, those are the things. If you take a photo when they are not ready to be taken in that way, it's also a breach of privacy. So I'm just saying that if you now take a photo of Diego, for instance, or of Munyala, and take it to the billboard, those are breaches in image rights, because they make money from the use of the image. Because you know why image rights are important? Because the celebs endorse goods and services, and they make money by endorsement. If you use it, if you take their photo and use it against a business to promote or do anything, then you are in breach of their image rights. I hope it's more clear. And Juki, I think you had Martin Juki. I don't know if you have the question. Okay. As we are waiting for Njuki, we have another question. Hilary, what are the copyright regulations to government images? The ones from Presidential Service Unit or Kekobo. And this, in our law, there's actually copyright in government items. And it's something that probably we need to review. So I'm not sure. You may have to ask how they want them to be used. But in most cases, there are photos of people doing their public related jobs. And, I'm sure the president will not mind his photo opening the expressway being used, unless you now use it to create a controversy. So there is a way to use that also helps. With regard to Creative Commons, it's difficult to do due diligence actual work. But I think Liz will have a way of saying this. It's about really, do we know, do we read the terms and conditions? Or do we just go look for the end and click?
Click accept.
Accept. Yeah, that's the problem. Well, I see. I think this is also a problem, but I think Liz can also say it's not very difficult in my view. Creative Commons are designed for simplicity. That means they will tell you copy and use alike. It's very simple. You know, so probably it's just you need to take time to understand it. And I think maybe sometimes we may have an opportunity to discuss the use of Creative Commons licenses as an option of managing. Then there's, I'll come to you, Liz, before we leave. And then there is a limitation of time under which one can institute proceedings. I think that one is true. So if you don't take, sometimes there's a limitation of Actions Act. So you have to be very careful about the time. So time is of essence in everything, because otherwise then it's something else. Yeah. At one point, somebody, Ricky says I was a photographer at a burial. The postmortem needed to be done. Later, the family was asking for those photos, and I refused to give them. Was I wrong? Those are moral issues, Ricky's. Yeah, I think there is a reason why you did what you did. You will not be able to help me. There is Isaac saying clarify on gentleman's agreement and the mention of use of social media to ask for rights transfer in Kenya. I think that was David who mentioned it. But, gentleman agreement means that it's oral. It's problematic to prove that you had an agreement. So with a word against yours, it's a waste of time. It becomes very difficult. Okay. So David, maybe you can talk about the use of social media. Or was it Liz who said people are bringing rights into
issues. Yeah, it was Liz.
And then Liz, you can also address the issue of Creative Commons. I think then we will close. I think we just ran out, actually 10 minutes out of time. Yeah, please, Liz.
Okay. So David, do we share? You address the gentleman agreement, and I address Creative Commons.
Please.
That's okay.
Okay. So I think I'll just address Creative Commons. Creative Commons si kazi ya kanisa. It's not payment by exposure. I think it's important. First, it's about reading the fine print. The ethos behind Creative Commons is, when we look at IP law generally as a body of law, it's not only about ownership. It's not only about yangu. It's also about improvement of lives, introducing solutions, growing the body of knowledge. That is why the various rights we have, including copyright, expire at one point. These rights expire. So for example, when you look at, for us in copyright, for works outside photographical works, it's the lifetime of the author plus 50 years. For the photographer, it's 50 years from the date it was made public, or from the date it was taken or published, depending, but thereabouts. Chances are it usually happens at the same time. For a broadcast, it's 50 years from the date it was broadcasted. So it will vary. When we're talking about patents, for example, it will be for 20 years from the date it was filed, and rather a certificate was granted. So then what happens is now it goes into the public domain. When it's in the public domain, it now it helps other similar thinking or other like-minded people to create something new, to contribute and take it to the next level. But do you want to wait until these rights have lapsed for you to be able to contribute? Do you, the Creative Commons license is actually a very creative way of marketing, especially for us African authors and creators. We've not understood this. When you look at Hollywood, I like to give this example. When you look at Hollywood and, for example, when it comes to pictures, how they find photographers for some of their Hollywood movies, they get to see these people's work. They have access to use this work in maybe presentations, in pitch job shoots in the advertising world. So that now they're able to say, when the client says, oh, I like it, they're like, find me that photographer. Yeah. When Asigei said, when you put all this information online, contact details are there, ziko hapo, we already know, oh, photographer David. Immediately they go and ping, dear David, we are excited about this. We have this opportunity. Please come to our office. There's something is cooking for you. Yeah, so that's what Creative Commons does. So read the fine print as well and see where it says share alike, when it says you cannot commercialize. So again, even you as a photographer also, you have to be very deliberate with how you're using the license. Again, if you use it without understanding what you're trying to do as a business person, as a photographer, versus what you want to achieve as well, unaweza noa, you can simply sort of, your ship can sink. Yeah, so it's about reading the fine print. But no, Creative Commons actually helps escalate your career to the next level. We have seen, have you asked yourself why, when you're looking at Hollywood movies and they have that East African theme, why is music being scored by foreign musicians? Yeah, because they're not able to sample our songs, yet they're very generous. They will put 2 minutes, 1.5 minutes on a Creative Commons license, and they're able to show what they can do, so that now someone else will, so an interested party will come and say, you know what, I have actually had your work. I think you can deliver what I want. You will understand my brief, because they have sampled. And what you've done, you've protected yourself. You're not saying, chukua, use it for free. You've been able, share alike, you can do. So I think it's about making informed decisions. Thanks. David, over to you.
Yeah, yes, the issue of Creative Commons, we may add before David comes in, is like when you have been given forms. Copyright is generally very complicated, but it's like where you are now being given forms just to fill, depending on the type of thing you want to do. You want to transfer, you want to do something. So it gives you a structured system, very simple when you understand it. But it looks complicated, like all legal matters, but it's really very, very simple. David?
The issue of transfer of rights by gentleman's agreement, I'd like to state that first, that is not as per the Copyright Act. The Copyright Act says if you're transferring rights, it has to be written down. So if you end up shaking hands with people, then you give them your photography to use, basically enforceability will be very difficult. And that is why it is the issue of when your photo is used and you want to assert your rights, it's very important that you request to be given credit if they use the photo without you. There are situations, and that is the issue I wanted to talk about when we're talking about RMI. There are works known as orphan works. Orphan works are works whereby you cannot find who created the works. For example, there's a photo lingering, and we do not know who took the photo. And that is where an institution like Kenya Copyright Board that has a rights registration, whatever system, and they record all these things. If you show you put enough due diligence to find out who took this photo and you did not find, you can use it as a defense if you end up using it and the owner finally shows up, because there's a rights management system. Also, you can use the rights management system to find this author who cannot be found, because when you're registering, you give your personal details, your email address, your phone number. So you might not find this person physically, he might have relocated, but through the rights management system, you can be able to do what? To find this person where you want to use orphaned works. So make sure that all transfer of rights are written down and signed by both parties for enforceability.
No, yes, it's very, very key. And I think we'll have to end it there. We're gone beyond by a long while. So we have to thank Liz and David for staying on, for their time, and for the research that they have put in, and being ready to share knowledge and information for other Kenyans. So I appreciate, I think, work together for a long time. Look forward to working with you again in future. I would also like to thank my team and the participants for being here, and watch out for our recording. If there are any questions, please follow us on Twitter, Facebook, or those other social medias that I don't know. You can also reach us on our website. You can get much more information. It's very likely that this recording will first appear there. So thank you very much once again, and we appreciate it. And I think